What's happening? LA's, make some noise. Looks like you guys are sleeping. What's happening, guys? All right. As you can tell, I didn't get the memo, so I'm wearing a red t-shirt while they're all in suit. How many of you are here doing an ICO? Raise your hands. So 1, 2, 3, 4, 5 in the back, 6, 7, 8, 9, 10, 11, 12. So what is everybody else doing? What are you guys here for? I think everybody should do an ICO, don't you think? No? Yes? The state of California is going to go bankrupt, right? What do you think the state of California is going to do in the next 24, 48 months? They're going to do an ICO, all right? What do you think California is going to say to SEC? Like, oh, it's not a security token, guys, it's a utility. You know, when you retire, you take this token, come to our bank account, and we'll give you some money, right? All right, jokes aside, let's get the panel started. My name is Kumar. I do token sale orchestrations during daytime, basically help with your legal, taxes, jurisdiction. I help shrink your timeline to do an ICO. So if you can help reduce even 1 to 2 months in your token sale project, then you're already coming out in the positive. And then in the evening, I do BlockCon, which is basically a blockchain conference. I do MarriageCon, which is helping, how do you 10x your partners?
Hi, I'm just, wow. Usually the room clears out when the lawyers get on stage, so I'm just shocked. So I'm glad that you guys all stayed in for us. I'm Jeff Marks. I am a corporate and securities lawyer in Newport Beach and an entrepreneur. And I've been a securities lawyer for 20 years, been in the crypto space for about a year, and worked on a lot of interesting deals, including the Kodak coin deal, which got a lot of publicity, and glad to be here.
Hi, I'm Ryan Azlein. I'm a partner at the Stradling law firm. I'm based here in Los Angeles, also a corporate securities lawyer. I've been practicing for about 20 years as well. Do a broad base of corporate and transactional work with a lot of technology companies, and we've gotten pretty involved in the blockchain and ICO space over the last couple of years as well.
My name is Marty Tate. The reason why there's so many people is they've created this false demand out there by only letting certain people in the door. They make you think that there's something more exciting in here than there actually is. But my background is in corporate securities as well. I was very active and continue to be very active in the crowdfunding space. Participated in the Crowd Invest Summit, which is what this was the past 2 years. In fact, I think Jeff and I were on a panel the last time, and there was maybe 1 or 2 questions about token sales and ICOs, and you know, now it's all crypto, and but it's great.
Hi, I'm Jor Law. I'm a corporate securities attorney as well. Co-founder of VerifyInvestor.com, which is a credit investor verification platform that's widely used in the crypto space. These days, I spend most of my time just advising and helping build out the ecosystem for tokenizing securities and exchanging them through a regulated manner.
Hi, I'm Dat Nguyen with Sagewise, not Amy Wan. Just Amy couldn't make it today. But Sagewise is a safety net for smart contracts. Mostly we work and help companies develop governance structures. I think one of the most biggest barriers to widespread adoption of blockchain is recourse, reliability, and kind of governance. So like, you know, if you have a dispute or something with a vendor or anything like that, currently there's really no, after you've transferred your transaction, there's really no way for you to get that back. So we work with companies to build an infrastructure. Ultimately, part of that is smart contract management, as well as ultimately, if all that goes awry, we have a alternative dispute resolution platform where you can come and get resolution and ultimately collections as well. prior to this, I was an IP attorney, and so I cannot talk about ICOs and stuff, but if you want to ask about patents and stuff in the blockchain space, I'm more than happy to talk about that.
Well, why don't we actually start with that, right? You are an IP attorney, so we'll ask you something related to that. I want to give the audience somewhat of a realistic viewpoint, so I'll just use an example. I know Elon Musk couldn't be here, so he did ask me to ask you guys, what if he did an ICO for Tesla, right? What would your advice be, two-step process for him from a legal IP standpoint that he should be looking at? Dat will go with you first.
Sure. So Elon Musk, and his companies believe in kind of getting patents, but they're not going to enforce them. And so he believes that it should be left to the open for the public to use. I think that's great, but I think the current state of blockchain patenting, it's pretty new. I actually checked this morning. There's about 800 patents in just with referencing the word blockchain. So that's, I would think that's pretty small for such a large invention that we have. If you just think about generally just network patents, there's just thousands upon thousands of them. So that said, there's a lot of players and a lot of movers in the space right now. Goldman Sachs, Bank of America, a lot of the financial institutions have started patenting. Last year, about 200 patents were filed by Chinese firms as well. And so while his company might not be interested in maintaining protection, he's still getting them. And I think a lot of blockchain companies right now, if you're kind of innovating in the space, I think patents is definitely something you should keep in mind, if not as an offensive tool, but definitely as a defensive tool. Currently, there's many ways that the space can move, and I think ultimately what will happen is like they'll move in the same space as kind of telecommunications, where these companies will kind of pull their patents together and have cross-licensing and agreements not to sue each other. But there's also that wild card out there where there are a lot of parties that I've been following that are pretty much patent trolls, and they're gonna, they know you guys, the ICOs got money, so I can see some suits coming in the near future.
But I haven't seen that angle being taken with any of the firms that, in the past couple of months that, go through an ICO process where, like, hey, we're building a product X, oh, let me think of it, oh, I have to go through an IP hurdle, or I need to make sure that I have some of the patents listed. I haven't seen that, so where would this actually apply? Are you talking about people who are about to do an ICO, do the fundraise, they should do that at that process? Or are you talking about do the fundraise, come back, and when you're building the product, make sure you're not infringing on an IP? Because majority of the blockchain stuff is open source protocol.
Absolutely. So there's two points to that question. And the first is open source and source code. That's related to copyright. And the second component that you're talking about is patents. So I'll attack them individually. So first is the open source. I think currently most of the platforms and most of the code that's open source right now is kind of on a very broad MIT license. So you're free to use that, make derivative products and all that, and you're pretty much okay. If you kind of continue to adopt that approach, and that's fine. The main thing with open source is that you have to respect or maintain the same type of license that you take. And there's some variance in that, and so you can go check opensource.org, and they have this elaborate chart, and it'll tell you if you want to move from one type of open source license to another,
right.
It'll tell you whether or not that's possible. And so strategically, that's something you should do from day one.
Got it.
And then as it relates to patents, there's a statutory bar. So most ICOs will probably issue something like a white paper. That's a public disclosure. So under the USPTO rules, the moment you publicly disclose your patent, you have a 1-year time clock to file a patent. So that's something all founders and all CEOs should keep in mind. And so you should at least consider and consult with a patent attorney or someone within, after issuing your white paper, so that you're not going to shoot yourself in the foot. Because if you wait past that 1-year mark, you're actually barred from getting a patent.
Got it. So that's actually a good action item. I didn't realize that you had 365 days. Great. So I'll move on to your, using the same example, if I were to use Tesla as an ICO, what are the 2 or the top 3 things you would ask the founder to actually take a deep look at or actually do it before they start doing the ICO or the token sale?
You know, I think I'd be interested in purpose and utility. Like, what are you doing the ICO for? Do you need to do the ICO? You know, is there utility behind the tokens that you're planning to create? That'd be interesting to me. And then the second thing, I think I'd be very interested in, you know, given that it's Tesla, you know, values and all that, I'd be very interested in token economics and to an extent that it wasn't utility and it was more of an investment, whether the investment makes sense, because I think a lot of the overhyped ICOs have some struggle on the investment, you know, soundness.
Got it. So make sure you have the IP, or at least take a look at that. Make sure you have some kind of purpose, utility, and token economics. What would you say, Marty?
I think the this builds upon what Jor said, but I would ask him why. I mean, why do you want to do an ICO? I think that
because we're about to go bankrupt.
But Tesla is not. Tesla is not going to go back. I think, and this question comes up a lot because I get, and I'm sure we all get calls saying I want to do an ICO, and in addition to the questions which Jor asked, which is great. What is the purpose? What functionality would your token do? But the question I always ask is why? Why do you want to do this versus a traditional equity raise? Most of the people that want to do ICOs, at least that are coming to me, they want to raise capital, and they see an ICO as a great way to do that, which I think it is, but they also, I think there's this perception out there that there's all this free money to go out and grab, and we have to do an ICO to do it. And unfortunately, or fortunately, because of securities laws, they're going to have to comply with securities laws. They're going to have to comply with those regulations, and then you have to really ask the question, why do you want to do it, structure it as a token sale versus just selling equity or debt in your company? Sorry, that's like not a popular answer for this crowd, but.
So you guys already know that I'm on the other side of the equation, which is I believe everything can be a utility token, but I'll leave that as is. Talking about securities versus utilities, do you guys believe everything is a security? And I'll let Jeff and you don't have a mic? Okay.
So your question is everything a security?
Is everything a security, or can there be a path between one or the other?
Yeah. You know? I would say the answer is no, or at least should be no, right? Not everything should be considered a security. Exactly where that line is the big question. And even, you know, in a couple recent statements, the SEC has opened the door where, yeah, theoretically there are things that are not a security and are purely for utility, but
like laundromat tokens,
exactly, laundromat tokens. So yeah, not everything should be a security. The question is, where's the line drawn? And right now we're still, you know, in the time period of figuring that out and seeing where things will land.
So what happens to all the entrepreneurs here who wake up and want to do some kind of a token sale, and they're like, okay, shoot, I don't know if it's a security. I want to make it as a utility. What happens to that?
You hedge. You create a structure for your offering so you can kind of hedge it and play it out. I mean, generally most companies are not going to issue their tokens for some time. They're raising money to develop their ecosystems. And so you create a structure where you don't actually issue the token right now. You can't. You kind of hedge it out and hope that the laws are cleared up a little bit more and there's more guidance such that when you're ready to issue your token, there might be some law to support that it's not a security.
How do you hedge it out?
Well, you know, there's something called a SAFT, which the SEC doesn't really like. The way we structured a recent offering, though, which the SEC did not approve it, and in no way did they improve it. This is a big disclaimer. But we got the sense that structuring it as a traditional SAFT where it's not automatically convertible into a token, where it's actually at the option of the holder at such time as the token is ready to be issued, where it's at their option to convert it, seems to be an interesting structure that might work.
Got it.
Is that true even if that's basically the only option?
What's the equivalent of a preferred stock with just liquidation rights?
But then you're stuck as securities anyway.
That's correct.
Another option, which again not that much better, is we've structured them where that conversion is A, optional, which I think is really important, but B, it can either convert into equity, which could or may not be tokenized, or into some sort of future quote unquote utility token or token that would be used within that network. I think that's, and if they decide to not do either one of those, then there's basically repurchase rights with some premium.
Right. Well, for some reason, I'm not feeling the SAFT part of it. And I'll just use the Tesla analogy. Let's say Tesla does an ICO and says we are a utility token. As long as you hold the utility and request for a Tesla car, it'll automatically drive to you. You sit in it. It's just like an Uber model, drives you, and you drop off, and you're done. And only the people who hold the utility token have access to this feature, right? In that scenario, how would we hedge our bets and go through like the SAFT and so forth? Because eventually you're going to hit the security side of it, right?
Well, in that scenario, it sounds like it's already built, right? That token exists.
Yes.
Right? So, and if that's a situation where the token already exists, and the people are purchasing that token so that they can have that utility, so they can drive the car. Again, there's no bright line, but that would seem to be more on the utility side. Less of a security, because utility and security tokens aren't mutually exclusive. A lot of utility tokens are securities. But that would tend to be safer. Now, if people were buying that Tesla
Safter.
Safter, I like it, Jeff.
Tough crowd.
Come on. So, but if they were buying that Tesla token because it was going to be traded on an exchange and they were speculating that it was going to go up and up and up, then it's looking more like a security.
Yeah, the SAFT, I think, is where you're not going to have a token developed for some time. There's nothing to issue. And you're just kind of kicking the can down the road, hoping some laws come out.
Right, and how long can they do this? Is it like a 30-day, 60-day, or they can just indefinitely? Like, I thought there was some kind of a time period that once you start doing your pre-sale or your private sale, that you have X amount of days to come out with some kind of a product, some kind of a functionality, because if you don't, then you're running afoul of some rules and regulations.
I'm not aware of anything.
No, no, I don't think so. But it's one thing that goes off what Marty said is it's important. I think people have kind of screwed up. The SEC's kind of screwed up in the sense that they've kind of led people to think that it's like utility versus security, and that it's a token that decides that. The confusion in all of this is that you could have a purely utility token, but if you sell it the wrong way, then they'll still consider it a securities offering. Now, nobody says that that's a securities offering. They just start calling it a securities token. But that's where I think the confusion is that you could have a 100% utility token that is still a securities offering.
Right, and to, again, hit on another point that was discussed earlier, to stress that, how you market it and sell it is important in the SEC's eyes and the statements they've made. So whether if you're playing up the fact that there's going to be a market for this and it's going to appreciate in value based on speculation, that's more likely treated as a securities offering, or would be in the SEC's eyes.
Got it. So what are I'll take the flip side then. What are the two things we shouldn't be doing or that would be running afoul of SEC? Like just the topics you're talking about. Like, can I have Kim Kardashian do a tweet about my product? Would that be awkward? Or what are the, or one thing that you would recommend our audience, like, hey, do not do X, don't make your omelet like this, or don't do your disclosures like this, or XYZ. I'll let Jeff go first.
Yeah, do not state that you're going to be trading on a crypto exchange the next 10 days or anything of such nature. I see that a lot.
Unless your tokens are tradable and you do have an exchange contract and you are going to be trading on exchange legally.
Yeah.
Of
in
course.
which case you would still, you'd be treated as a security, right? What are we trying to avoid here when you say making this omelet? Are we trying to say we want to avoid?
Well, you guys are the lawyers. I'm just asking the question.
Yeah,
so what are the things I should not be doing?
Some people look really good in orange, right? So I think that, the other thing is you want to make sure that not only that you won't be traded on, that there, I think it was It was either the Dow or Munchie that basically said, you'll have a chance, those will be traded, like Jeff said, and you'll have a chance to be, to profit from that trade. That's pretty bad. That's pretty bad in any securities world, utility world.
So why is that? Why not let people gamble? I mean, if they are going to buy a token because it's going to appreciate in price, why not? Let them do it. What's the big hurdle? I don't understand that. I mean, we are human beings. I mean, we go to a 4-year college hoping that we get a higher paying job. I mean, that's in fact a gamble as well in its purest form. Why not let people gamble on tokens? What's the big deal?
Because we've got a government that likes to protect us. Now, not like our government ever goes overboard or anything. Finally, I got a laugh. Thank you. But we've got a government that's trying to protect people, and they enacted a Securities Act to protect people really from fraud. And of course, things are a little bit overboard, but I mean, they're trying to protect people. And
but how is that protecting people? I mean, if everybody is able to even put like on a scaled down version, let's say if you put $5 of your salary into an ICO, and at least become you educate yourself. But $5 is not going to hurt. $10 is not going to hurt. Why just strictly create a class barrier, which says only these people can invest? And hey, you know what? Majority of the folks, we don't care about you.
They're moving in that direction a little bit. When they came into the Jobs Act and allowed that sort of crowdfunding, they started allowing more folks to do it. It's still overly regulated. It's kind of burdensome. But I do think that in a new economy where things are getting decentralized and more kind of market to the masses, I do think the regulation will catch up. A lot of it is just education. You've got I think you've got a culture where people aren't trained to really invest for themselves that way, and kind of when you catch up the education system and show that people can take care of themselves, I think the regulations will allow people to take care of themselves.
And I think when people gamble, they know they're gambling, right? When you buy in an ICO, and I think people think, well, I'm making an investment. And ultimately, I think regulators have to be really careful because they're the first call that gets made. When people lose money, the investors will, if they can't get a hold of the company, they'll call the regulators. So maybe they're just doing it they don't like answering the phone. I don't know.
Kurt, you didn't see, but there was a sign that came out that said we have 3 minutes.
Oh, okay. Anybody has questions, I'll actually just let it open.
Americans who are launching ICOs in different countries to kind of hide behind their country, what kind of exposure do they have, when they raise $100 million and the IRS starts looking at their income and everything else?
That's actually a $100,000 question that you're asking.
So I was curious as attorneys, could you elaborate what's the exposure?
It's high. Your exposure's pretty high, I think. If you're a U.S. company,
U.S. citizen.
Oh, U.S. citizen.
The companies are launched abroad, in the Caymans or Panama or whatever. Where are your companies?
Yeah.
But are you guys all actually out there, or is there?
See, basically what happens is if you're going to do a token sale or a token generation entity outside of the US, there are various tax mitigation strategies that will come into play. So you can either hold that particular entity directly, and if you're holding more than 10% of that entity, you do have some tax ramifications.
if you're selling to U.S. investors, then you got to comply with the U.S. securities laws, even if you're a Cayman Islands company.
You can either do world minus US and have certain steps on your landing page which says if you're a US citizen, this is not for you, do it. I'm not a lawyer, but until unless you're
I think
touching a
if the
US
money's
citizen.
flowing back into, if there's a nexus to the United States, if the money's flowing back in the United States, I don't think you're protected. They've gone after Hong Kong entities because they've had sufficient connections to the U.S. It's a question we get a lot about, well, we'll set up in the BVI. There are structures you can do to mitigate those risks, but it's definitely not foolproof.
If you guys have questions, we'll take maybe 3-4 more, and you can line up right here.
Thank you. I haven't heard a lot today about Reggae Plus. Why not?
Nobody asked. You're the first one. Reg A Plus is a very interesting vehicle. One thing that a lot of companies are thinking about raising their initial capital, but they're not thinking about how they're going to issue tokens in their token economy. Because, you know, if you issue what is deemed a security to contributors, you know, in your economy, that is a securities issuance. And you can't do that. You can't make those issuances to unaccredited investors without like an exemption like Reg A Plus. Reg A Plus could be a very useful.
Yeah, I think it's a great solution. I think it's the best thing that we have going for us as far as doing ICOs and token sales, for sure.
Yeah, I mean, look, the Jobs Act has been around for a while. There's been Reg A Plus, Reg CF, and 506C. You know, the truth is in the numbers, right? Most people choose 506C. They do it for a reason. There's a reason why Reg A Plus has been so unsuccessful over the last couple of years. It's just it's harder to use. It's more expensive to do. I think you'll get some ICOs using it. I think when ICOs start trying to trade on the secondary market, if they're not doing it properly, they may be surprised how easily they could trade those tokens or not.
I'm seeing more and more companies rewarding workers or contractors with cryptocurrency, and I'm not seeing too many people talking about like W-9s, 1099s, and no one's really talking about this. You guys have any insights there, whether it's influencer marketing or, you know, subcontracting or, you know, bounties?
It's definitely an issue. If you're getting compensated, it's income of some sort, and it might also affect whether your tokens are securities or not. If they're being treated essentially as compensation, that would make them look more like securities.
Right. So for my company, TribeCoin, we allow people to use the token to purchase products in a marketplace. So in the context of a utility use case, do you see that applicability still being highly relevant?
Does someone want to do that? I know what I would say, you know, which would be.
Yes, potentially. Need more facts.
I think you'd also, again, like Jor said, there's a high probability that token that you're issuing might be a security, in which case you'd have to issue it, which is possible. You could issue it pursuant to an exemption for like an employee, you know, benefit plan. But it really just depends on how that's treated. But and if it's not a security, there are definitely tax implications as well.
It's not an ICO though. It's transactional or on the side chain of another token. I don't know if that changes it, but I need a lawyer.
There's a phantom income tax.
Awesome lawyers right here.
There's a phantom income tax issue. So you give your employee $20,000 worth of tokens, and the IRS comes in and audits him. He's got to pay, you know, $6,000 or $7,000 in taxes on money where he received tokens and not cash.
Why don't we take this off the floor?
Assuming they got audited.
We'll take one more question because we are getting off the stage. Everybody else, you can meet. All of them are here on the floor, so you can ask your questions afterwards as well.
If we can knowingly, intelligently, and voluntarily waive our right to counsel in a criminal trial as a defendant, why can't we waive our right to be protected by the SEC, and can we lobby and write legislation proactively to take their power away from us?
Anybody want to take that? Give it to the non-lawyer guy.
That's a great way to end, though.
All right, well, I think that was a. Do you guys want to answer that question or no?
Well, we'd be out of a job, first of all.
There'd be no SEC, right?
I mean, not all rights are waivable. So, you know, maybe this falls into one of those things. But it's a good question.
Yeah, well, you can waive your right to obviously bring an action against the person that sold you the token. But you know, one thing, and I've said this in other things, we're basing a lot of this. Obviously, the Jobs Act was 2012, but the Securities Act was 1933. I think it's obvious we need a 2020 act instead of a 1933 act. So hopefully, we can see some movement towards that.
Well, on that note, thank you, gentlemen. Thank you for your insights, and thank you. Love you all.